America's center of power changed, and with it, the dynamics of the political landscape. The consequences will reverberate locally, in Florida, on Capitol Hill, and on the global stage. Voters demanded change on the issues that mattered most: the economy, immigration, and social issues. Now, News4JAX goes beyond the headlines with political analysts who provide unique context and perspective. Experts focused on the issues making headlines. This is Politics and Power.
The Supreme Court is tackling several issues in its new term that President Trump has voiced strong views on. The president's ability to shape political life will be determined by the court's actions, and its decisions will have momentous significance. The legal scrutiny will be intense. They'll discuss what will be a major thrust of the court's actions over the next 10 months, much of it centered on the justices' evaluation of the president's expansive claims of presidential power. The court's conservative majority has so far been receptive, at least in preliminary rulings, to many emergency appeals from Trump's Republican administration. But there could be more skepticism when the court conducts in-depth examinations of some Trump policies. There are other things at stake. For ethnic minorities, it's political representation, the often debated legitimacy of mail-in ballots, whether tariffs are legal, and whether President Trump has the power to fire a board member of the Federal Reserve. Welcome to Politics and Power. I'm Bruce Hamilton. Joining me, constitutional law expert Rod Sullivan, a frequent guest here. Appreciate you being here.
Nice to be here.
So let's start with Louisiana versus Calais. It's a case that could decide whether Section 2 of the Voting Rights Act conflicts with the Constitution by requiring states to create majority-minority districts.
Yeah, I mean, first of all, you need to understand the facts. The Louisiana legislature created an electoral districting plan, which created one majority black district. And people went to court and they challenged it. They said, no, we have this many African Americans in Louisiana. We need 2 African American districts. And the court said, yeah, I'm requiring you to create 2 African American districts. Now, the Voting Rights Act was passed with a majority in both houses of Congress, and it specifically said that nothing in this act creates the right to proportional representation of a protected group, predominantly race. And it was a lengthy debate, and I brought these props with me so you can see, how much went into this discussion. And what finally happened, what people were saying was, if we pass this Section 2 of the Voting Rights Act, they're gonna create quotas. They're going to say, we need to have this many black districts, we need to have this many Hispanic districts, and so on and so forth. And so the Senate wouldn't go along. Finally, Orrin Hatch said, hey, I got to compromise. We're going to put something in the act that says nothing in this act is going to give any minority group a right to proportional representation in the House of Representatives. For a lot of senators, that wasn't enough. They said, no, the courts will misinterpret this. They'll just ignore what we said. And the other senators said, no, the courts will listen to us. I mean, we're the lawgivers. We make this law. And so they passed the Voting Rights Act, Section 2. In other words, they didn't change the whole Voting Rights Act. If there are still practices which discriminate against African Americans, you can go in and file suit. Nothing is going to change. But what this changed is this practice of creating proportional representation. So this case went to Louisiana, and the Louisiana court, or the Louisiana plaintiffs, Calais and a dozen other people, said, this violates our rights under the Constitution. We are not getting equal protection. We are not getting the right to vote. We are being congregated in a majority-minority district, even though we're not in the minority. And therefore, you're telling us that we have to have a representative of a particular race. Now, this case went to the Supreme Court already once. It went to the Supreme Court in the spring term. And in the spring term, the court couldn't agree, or at least didn't agree, and said, okay, we're giving you another question. And the question we're going to ask you is this: does the creation of minority access districts that don't follow traditional districting procedures, does that violate the 14th and 15th Amendment as to majority voters that are in those districts? And so that's what's up on appeal this time. Now, the question that you proposed to me is this a racial gerrymander? And you don't have to be a constitutional law expert. All you got to do is look at the map. if you look at the map and it shows where all the 50% or more African American precincts are throughout the entire state of Louisiana, and it forms a line throughout the state. It divides the state in two. And guess where these two districts are? They're here and here. They're 2 and 3. They are African American districts drawn based upon the lines of where African Americans live. So race was the predominant factor. You know, they didn't follow traditional county boundaries. They didn't follow city boundaries. They didn't follow community boundaries. They didn't follow marketing, media boundaries. They followed race. They said, if you're black, you're going to be in the 2nd or 3rd district, and if you happen to live adjacent to those districts, that's going to be your representative. So people said when they passed the Voting Rights Act, this would never happen. But this has really had been a violation of the rule of law. You know, the rule of law is that Congress makes the laws and the courts interpret the laws. In this case, what happened is the courts looked at the law. They looked at all this, these debates, all these people saying that proportional representation couldn't happen under the Hatch Compromise, and they did it anyway. And you saw what happened in Florida.
I was going to say, we did see it happen here.
Oh, it was terrible.
There was a big debate about it.
Oh, absolutely. Corrine Brown would never have been in Congress except for the way the 3rd Congressional District was drawn. It started up all in Jacksonville. It weaved its way across the state, capturing every African-American neighborhood along I-10, made a left turn, went through Gainesville, but just got the African-American population, went all the way down to Orlando. It wasn't even contiguous. That means that there were portions of the district that weren't joined together by anything except railroad tracks and roads. No houses. We're just going to say the railroad track to here in Bayard, that's part of this congressional district. Why? Because there are African-American voters in Bayard and there are African-American voters in Jacksonville, and we want to link them together. And then it went down Phillips Highway, taking in African-American neighborhoods. So Corrine Brown got elected to Congress solely because we created a black district. Who else got elected? Well, Alcee Hastings got elected to. Now, most of you don't know who Alcee Hastings was.
Former Supreme Court Justice here in Florida.
Yes, District Court Justice. He's a District Court Judge down in Miami, and he was caught making phone calls, accepting bribes on the courthouse phones. He never suspected they would tap the phones in the federal courthouse. And he was tried, and there was a hung jury. He was tried again, there was a hung jury. 3rd time around, they found a jury that would acquit him. And then then Congress took it up and said, Alcee Hastings, you're not fit to be a federal judge. We are going to impeach you from office. And he says, no, that's fine. I'm going to run for Congress. I live in a minority access district. And he served in Congress even though he was on video, on audio, having taken bribes, and he had been impeached by the House. So the effect of this Voting Rights Act Section 2 has been to divide us into tribes. You know, people say, why are we so divided today? We're divided today because the court said we had to be divided. You're not a resident of Jacksonville, you're a black resident. And therefore, we will put you with other black residents in Gainesville and Orlando, wherever it may be. And if you're a Hispanic, we're going to take you and we're going to put you in a Hispanic district that takes in Miami and then weaves its way through to get all the Hispanic districts in South Florida.
Back to the term proportionality you were talking about.
I'm sorry?
Back to the term proportionality you were using before.
Yeah, well, we have proportionality still. We're not as bad as we used to be, but we still have these bizarrely shaped districts. And consequently, we are a nation no longer of communities, no longer of cities and counties. We are a nation of tribes. And if you're white, you're a member of the white tribe. And if you're black, you're a member of the black tribe. And you wonder why we're divided. Well, this started out as a small problem. We have 435 members in Congress. We have 120 minority access districts. So basically 25% of Congress is in seats that are assigned to a race. Now, you have to say to yourself, well, why does this happen? Why didn't the Republicans stop in and stop this from happening? Republicans love racial gerrymandering. Why? African Americans are reliably Democrat voters. If you can take all those African-American Democrat voters and put them in one district, what happens to each of the surrounding districts? They become safe Republican seats. And so Congress said, hey, this looks good to us. We like to be in Congress for the rest of our lives. We like a safe seat. So consequently, who benefits from racial gerrymandering? Well, certainly African Americans and Hispanics benefit. But the Democrat Party loses in general, and the Republican Party wins. And so this has continued on for 30 or 40 years. So this is the biggest challenge to the rule of law that we have had in our lifetimes here in the United States. We have courts that are disregarding what Congress says, and we have had them imposing their own sense of what they consider to be justice and ignoring the law. And consequently, what the Supreme Court, I believe, is going to do is going to say the Voting Rights Act does not require proportionality. It requires there to be a pre-existing proof that there's been some intentional discrimination based upon race. In the absence of that, we're going to apply strict scrutiny. That means it has to be narrowly tailored to satisfy a compelling governmental interest. And simply electing people on race is not a compelling governmental interest. So you posed the question to me before we got here today is, are they going to declare Section 2 of the Voting Rights Act to be unconstitutional? Absolutely not. If there's a violation of voting rights, you're going to still be able to go in court and you're going to be able to sue to get that corrected. What the court is going to say is no proportionality. We're not going to create minority citizens in a majority minority district. We're going to let everybody vote based upon the traditional redistricting factors. We're going to have equal districts. They're going to be nested in communities, around communities. They're going to follow traditional boundaries, and they're going to be compact, and they're going to be contiguous. So that's what I think. This is an important case, no question about it. Highly controversial case. I don't doubt that, but I think that's what the court's going to do.
What we see in the headlines these days is a lot of political gerrymandering. Is that any different?
It is. There's the separation of powers, and the court says that we are empowered to make decisions concerning racial gerrymandering, but that political gerrymandering falls within the context of the political branches of government, and therefore we are less inclined to intervene. So I don't think this is going to affect political gerrymandering, but it's going to have a tremendous effect on racial gerrymandering.
Does that political gerrymandering eventually wind up before the Supreme Court?
Oh yeah, I think it has, and I haven't looked at that recently, but that's my general understanding of where they came down, is that political gerrymandering is a political question, and that racial gerrymandering is a constitutional legal question.
All right. Staying on the election front, the court's considering Bost versus Illinois. This has to do with the counting of mail ballots, which has been a very controversial issue brought up by the Trump administration, brought up by Donald Trump.
Yeah. There are 16 jurisdictions in the United States which permit mail-in ballots to be counted after the day of the election. Now, the statute says federal elections shall be held the first Tuesday after the first Monday in November. So that's the law. But states like Illinois have said, well, mail, all that. So we're going to allow you to count mail-in ballots 14 days after the day of the election. Florida doesn't do that. In Florida, you need to have your vote in to the supervisor of elections office by 7 o'clock on election night, and that's it. It's over. But in Illinois, it was different. And not only in Illinois did you have to be postmarked by the date of the election and received within 14 days, you could even submit a ballot that wasn't postmarked, and they would still count it. Why would they do it? Well, they'd open up the envelope, and you would sign a certification. And if you signed a certification that said, I voted on this day, and that day was before Election Day, then they count it, even in no postmark at all. So Congressman Bost said, look, this violates the intent of the statute. The intent of the statute is we have one federal election day in this nation. Everybody votes on Election Day, and this opens up Illinois for fraud. Imagine that, Illinois voting fraud. Who would have thought? So he went to the courts, and the court said, well, I don't know if you have a case or not, but you don't have a concrete interest. And he's like, wait a second, I'm a congressman. I have been a congressman since 2015. People donate millions of dollars. I campaign all year round for 2 years to get reelected after I've just been elected. I don't have a concrete interest in seeing that this election is run according to the law. And they said, no, you would have a concrete interest if you could show that the mail-in ballots that were counted were enough to sway the election in your favor. So wait until you lose an election. We'll go ahead and install whoever wins the election in Congress, but you come to us then, you go through 2 years of litigation, and we'll decide your issue then. And so that's what happened. That's what happened in the district court. It went up to the Seventh Circuit Court of Appeals, and the Seventh Circuit said, yeah, that's right, you don't have standing, your interest is not concrete enough. Now, the Supreme Court wouldn't take a case like this if it didn't intend to massage or change the Seventh Circuit's ruling. So my belief is that they will reverse the Seventh Circuit. Will they create a firm rule as to what concreteness is? No, but I think they will determine that any congressman running for election probably has a sufficiently concrete injury to have standing to bring the lawsuit. That would be my prediction.
Yeah, building on what you were just talking about, 2 lower courts did throw the lawsuit out after concluding that the congressman lacked standing. President Trump and his allies have long criticized the practice of mail-in voting, using it as ammunition to cast doubt on the outcome of the 2020 election. We all know that. He said it's time that the Republicans get tough and stop it because the Democrats want it. It's the only way that they can get elected. That's the president's stance. Is this a legal issue or is it a political issue?
No, it's in my opinion, clearly a legal issue. Again, it's the rule of law. Congress said the rule is first Tuesday after the first Monday in November. And deciding that some other rule applies because you take your ballot and put it in an envelope, and we don't even know if they drop it in a mailbox if it doesn't have a postmark on it, is a violation of the rule of law. And it's a threat to democracy. And therefore, if the courts are really going to be interpreters of the law instead of making their own laws, then I think they need to adhere to what the law says.
So what's the Supreme Court's responsibility here? Is it to establish a clear rule for standing to litigate disputes over election laws?
Well, I don't think they can do that because, standing applies to every single litigant. And this is one particular litigant, a U.S. congressman. So I think they can create a clear rule that says somebody who's running for Congress has standing to challenge an election procedure that they perceive violates their possibility of getting elected or reelected. But I don't think it's going to be a concrete rule that's going to apply to every single situation.
The first case in the court's new term was Childs versus Salazar, and the court's considering the question of whether a Colorado law banning conversion therapy attempts to convert somebody's sexual orientation or gender identity violates the free speech clause of the First Amendment. This is a very controversial topic.
Well, it is. You have to understand, though, that in this case, that there's a constitutional right for free speech. There's no constitutional right to a particular type of medical treatment or medical care. So the argument on this case has already been held. I've listened to it.
Oral arguments, yeah.
Yeah, oral arguments have already been held. The case has already been briefed. It's dangerous to predict the outcome of a case based upon oral argument, but I think this could be a 7-2 decision. And why do I say that? Justice Kagan asked a very poignant question. She said, you mean a therapist can counsel a minor that they can convert their sex from whatever their gender or sex is at birth to some other sex, and that's okay. They can counsel them, they can tell them about hormone treatments and surgeries, walk them through the process. But if a counselor wants to say, you know what, you were born a male and you need to stay a male, you need to fight against these tendencies, we're going to deny that. You have the right to do that. So we have one group has one viewpoint, and that's permitted, as a matter of fact, encouraged, and one is absolutely prohibited. And Justice Kagan said, this sounds like the very kind of viewpoint discrimination which we have held against in many cases. And I think there was a hush in the courtroom when she said that. If Justice Kagan is not on board, there is no way that Colorado is going to win this case. You know, Colorado is the least free speech state in the nation. They keep bringing these cases up to the Supreme Court and they keep losing. They had Masterpiece Cake 1. You have to bake a cake. If somebody comes in and they want a cake with a homosexual message, you have to bake it. That went back down to the Colorado Civil Rights Commission. It came up with Masterpiece Cake 2. They lost again. Then we had 303 Creative. You know, this person was a Christian website creator. Somebody wanted him to create a transsexual website, and this woman said no. And they went to the Supreme Court, and the Supreme Court says, no, that's a creative process. She has the right to decide what she's going to create and not create. And so now we have the 4th free speech case from Colorado coming up in 5 or 6 years, and I predict they're going to lose this case as well. Now, the other side of this case is, oh, well, the American Medical Association and the American Psychiatric Association are both against conversion therapy. The thing is that they have studies that say types of conversion therapy, shock therapy, hormone therapy. There are apparently drugs which will create nausea surrounding sexual processes. And there are studies that say that all of these therapies are able to be prohibited, that they have harmful effects. But this woman, Miss Childs, wanted to do talk therapy. All she was going to do is talk to these people. And the state of Colorado says, you cannot talk to them about trying to change their sexuality. If they come into you, and by the way, we're only talking about minors. We're not talking about adults. If they and their parents can't come into you and say, we want to voluntarily get your treatment. We want to learn how to deal with these sexual urges brought by a teenager, and we want you to talk to this teenager about them, Colorado says, you cannot. You can talk to him about how to change his sex, but you can't talk to him about how to resist those urges. You can't talk to him about celibacy. That's not permitted. All that's permitted is to counsel them how to get converted, not how to avoid conversion. So I think this is one of those cases where even Justice Kagan looked and said, that's a bridge too far.
But there are those who believe it goes beyond the topic just at hand, and they say that how the justices rule could have far-reaching consequences for the regulation of medicine and the balancing of civil rights for the LGBTQ plus community and against religious freedoms.
Yeah, I think it will not. And the reason is because there's only one right that's mentioned in this particular case, and that's the right to speech. And because the right to speech is protected by the First Amendment, it's going to be treated differently. States are still going to be able to prohibit shock therapy. They're still going to be able to prohibit hormone therapy and other medical prescription drugs and procedures and things of that nature. Those are not protected by the Constitution. But if all you want to do is talk to your patient about their sexuality, talk to them about celibacy, talk to them about, leading a heterosexual life even if they have homosexual urges, you're going to be able to do that. That is a clearly protected speech under the Constitution.
Okay, again, oral arguments have been heard. We should expect a decision by summer.
June.
When Politics and Power continues, other cases before the High Court that test presidential power. Stay with us. Welcome back to Politics and Power. Bruce Hamilton with constitutional law expert Rod Sullivan. Rod, the Supreme Court is confronting a series of cases central to the president's agenda. In December, the court will examine the president's power to fire a leader of the Federal Trade Commission, revisiting a 90-year precedent that has allowed Congress to pass laws preventing presidents from removing independent regulators solely over policy disagreements. Now, Justice Clarence Thomas has an interesting take on precedent. He consistently argued that if a prior ruling is not based on a textually permissible interpretation of the law, it should be corrected regardless of other factors. Does this impact the situation?
Yeah, I mean, this boils down to a single case that none of your listeners have heard about called Humphrey's Executor. That happened during the Great Depression. And the Great Depression, Congress started creating, quote unquote, independent agencies that were not subject to the president, not subject to Congress, and they insulated these independent administrators from presidential control. And that has been the law for 90 years. And for 90 years, I taught administrative law in addition to treating constitutional law, and Humphrey's Executor was always a bone of contention because you don't vote for these people. You know, we're a democracy. Any time that you give somebody power who you have no vote over, you are surrendering democracy. That is a threat to democracy. But Congress did it. Congress created all these quote-unquote independent agencies and said, you can't fire these people, even if you're president. Even if the people vote for you because you say you're going to fire these people, you can't fire them. Well, that has always been a bone of contention. Is that true democracy? The Fed is the most important administrative agency in the United States. But what Congress has said is, you put somebody in the Fed and you cannot fire them. And so the question that, what Justice Thomas is saying is, if Humphrey's executor was never good law, if the Constitution never permits us to have governmental officials that can't be voted in and out by the president or by anybody, then that violates the spirit of democracy. The spirit of democracy is you get to choose your leaders. You don't like your leaders, you can vote them out. Can you vote out a Fed commissioner? No. Can you vote out any of these independent agency commissioners? No. So Justice Thomas's opinion is, I don't care if it's been around 90 years or 190 years, it was never textually correct. There should never be a public official who cannot be fired by the people. And so that's why I think he is going to vote in this case to permit the president to fire a Fed commissioner. The other question, the really more nitty-gritty question is, let's assume that in fact she did commit mortgage fraud, but she did it before she became a Fed commissioner. Is that considered to be misconduct such as that would permit the president to fire her for bad conduct? And that's probably the easier issue, and that's probably the issue that the court is going to stand on. And the court has sort of signaled that the quote-unquote the Fed is different, that the Fed is probably going to get to remain independent, but that a lot of these other administrative agencies that are allegedly independent, or that are supposed to be independent by Congress, are probably going to have their power curtailed because the president is going to be able to remove commissioners, even though Congress said that they should serve for life, serve for 14 years, whatever it may be.
Okay, so that was about the Federal Trade Commission. So let's go to this. Even before Mr. Trump returned to office, the Supreme Court's conservative majority had taken steps to make it easier for presidents to remove independent agency leaders, signaling it would be receptive to claims of executive power. So in January, the court will consider whether Mr. Trump can remove Lisa Cook, Federal Reserve Board governor. Justices signaled in a separate case that the Fed is uniquely independent, and their decision will have far-reaching implications for the central bank and the U.S. economy. Basically the same argument here?
Yeah, that's more of a political decision than it is a legal decision. If Justice Thomas is right, that the Constitution never established that you could give authority to somebody who can't be voted on by the people and cannot be removed by a president, then that should apply to the Fed as well. But the Supreme Court has sort of signaled that a Fed commissioner is different and that we're going to treat them differently. Is there any logic to that? No, that's really politics. That's really somebody saying, well, you know, a setting of interest rates is one of the most powerful, it's the most powerful administrative agency in the United States. We watch Fed meetings, we listen to the chairman of the Fed, we make our investments and decisions based upon what interest rates are going to do. So it appears that the Supreme Court is going to carve out the Fed and say that Congress was permitted to create a permanent Fed position that the president can't remove, but not other independent agencies.
Because there are different considerations there.
Yeah, different consideration, quote unquote pragmatic considerations. If the president could remove anybody for any reason, then the president would have control of interest rates. So I think that they're going to look upon it as a pragmatic question more than as a legal question.
Yeah, Steve Vladek, who's a professor at Georgetown Law, basically said that you can't read too much into the Supreme Court's preliminary orders, and he said we have to wait and see what they do in this term to see if they plan to curb the president's expansive use of executive power, because what they did preliminarily is different than what they're going to do during this term. Do you agree?
Yes, yeah. The emergency docket is a different kind of docket, basically a district court judge sitting in who knows where, San Francisco, Sacramento, New York, says, I'm issuing an injunction and I'm going to apply it to the entire United States. You may not have been before my court. You may not have even heard this case existed. You didn't come before me. You didn't have notice and opportunity to be heard. But I'm going to go ahead and issue an injunction that affects your life. And the court has indicated that these nationwide injunctions are going to be less favored in the future. And the emergency docket, they just come up to the court and they say, should the injunction stand or should it not? And the court votes without issuing a written opinion. So you don't know exactly why they did it. The other thing about the emergency docket is the Solicitor General decides to pick and choose which cases to take. So if a smart Solicitor General says, well, we can win this case, but we can't win this case, so let's bring the case we can win and not bring the case we can't win. So the record has been something like 25 cases brought, 23 in favor of the Trump administration. And that's because of the selection process. But just because the justices vote anonymously, without opinions, without briefing, without significant briefing, without amicus briefs, without significant oral argument on these particular issues, doesn't really give you an indication of how they're finally going to rule. So we don't know what they're going to do.
I think this goes to what you're saying here, that legal analysts, some say that one reason that the president has been so successful at the court so far was that his lawyers had been able to cherry pick which cases to bring to the justices, largely avoiding some of the thornier disputes. And the results had been an unrepresentative sample. So basically they're saying that the rulings so far don't really tell us how the court views the substance of what the administration's been planning. Probably a fair assessment.
Oh, I think that's exactly what's happening. The Solicitor General is picking cases that they can win. And if there's a nationwide injunction and they don't think they can beat it, they say, okay, well, we're just going to take it up through the normal system, which means it goes from the district court to the appellate court to the Supreme Court, and then the Supreme Court will handle it under full briefings. But the emergency doctrine is just that. It's an emergency. And consequently, you pick and choose which emergencies to take up to the court.
Yeah. Well, let's talk about the challenge and it is a challenge for the Chief Justice, John Roberts, right now. He is dealing with justices who are growing restless. He doesn't have a lot of partners on the bench. Is his biggest challenge in managing this somewhat more individualistic and fractious group of colleagues?
Well, it is, but I don't want you to think that this is any different for Justice Roberts than it has been for anybody else.
Warren had the same kind of court.
And Warren had the same kind of court. The thing about the Supreme Court that, Comey Barrett has written her biography. And anybody who's truly interested in the inner workings of the court, it really provides more insight than almost any biography I've written. But she indicates the worst thing that a Chief Justice can have is plurality opinions. That means an opinion that decides the case but doesn't have 5 or more justices on it, because it means nothing has happened. It doesn't bind the court in the future. It doesn't bind lower courts now. It's really just, you wasted your time. So what a Supreme Court justice has to do is put together a set of people and a set of arguments that will garner 5 votes for whatever the majority opinion is. And that's what Roberts' real problem is. I mean, he has 2 votes that are always going to be on the left, maybe even 3. Justice Kagan, maybe she goes back and forth. Sotomayor and Ketanji Brown, they're always going to be on the left. And then he has 2 justices that are always going to be on the right, Justice Alito and Justice Thomas. And then he has these other justices to work with. And his goal is, how can I get as many actual opinions that resolve cases by a 5 or more majority to come out of the court? And so there are compromises that he's making. So some people say, well, he's not holding to his principles. He is holding to the principle that the court is there to resolve the law. And just because if he can't resolve the law, why are they there? Why come out with a whole bunch of plurality decisions that mean nothing? Why don't we go ahead and resolve a case and give the country and the lawyers and lower court judges some guidance on what the law is? And so what he's trying to do is put together these 5-vote coalitions that are going to decide cases. Very, very difficult when you have 2 on the right, 2 on the left, and a few in the center who can be persuaded one way or the other. And so that, I think, is his challenge. And I think that's what he's doing. He is trying to put together as many decisions that make a difference as he possibly can.
You know, I did another show, and there were questions that were raised about Justice Roberts and where his head is at. You know, they look back to his confirmation hearings where he said, I'm going to be an umpire and I'm going to call balls and strikes, which I don't know that that's possible for a Chief Justice, any Chief Justice to do. And it was, the major question was, has the Roberts Court become the Trump court? Is he feeling undue pressure from President Trump? Is he his own man? And is he being a fair jurist?
As a Chief Justice, you don't get to be, quote unquote, your own man. You get to decide how your vote is going to go. And I think he holds to his own beliefs as to how he's going to vote on an issue. And he holds his own beliefs when he's going to take a decision and say, I'm writing the majority opinion here. But when it comes to these contentious issues where he has to put together a 5-vote majority, he's in a collegial body. He's not really in any different position than a committee chairman in the Senate or the House. He has to form a coalition. And I don't see him as surrendering his values as I do in his administering the court and putting together those 5-vote coalitions that are actually going to resolve cases.
But I think that the question has come about because for the first time we see publicly a president who doesn't seem to want to follow the rule of law.
He is testing every issue.
Testing every issue.
Yeah.
And that provides a unique challenge for Justice Roberts. He hasn't tested the Supreme Court yet.
No, he hasn't yet. And I don't think he will ever defy an order of the Supreme Court. You know, people say, oh, he's going to run again, or he's going to just, you know, not, he's going to do what President Jackson said, and well, let them enforce their own judgment. I don't think that's going to happen. But he is going to, let's just take the most contentious issue that he's put together in an executive order so far, and that's birthright citizenship. And anybody who thinks, you know, people will say, it's been this way for 250 years. That's not an excuse. That is not an answer to the question is this constitutional or is this not? And so Trump has said, I don't care if it's been the law for 250 years. The law is got some ambiguities in it. You have to be legally in this country in order to get the rights of birthright citizenship. And if you're not legally in this country, subject to the jurisdiction and laws of the United States, just because your body is here doesn't mean you don't get birthright citizenship. And anybody who thinks that that's an easy question that's already been resolved is really not being truthful. You have to look at these things and look at the language of the Constitution and you say, why did the people who voted on the Constitution put subject to the jurisdiction of the laws here? Does that mean that everybody who can be arrested because they're in the United States is subject to the jurisdiction of the United States? That doesn't make any sense. Why would you put that language in there? So when Trump signed the executive order, he says, yeah, we're going to have to challenge this in the courts. He didn't say this is the law. He said, I think that the law is ambiguous, and consequently, I'm going to go ahead and sign an executive order, and we're going to take it up to the courts and see what the courts have to say.
And Robert's legacy, when they look back on it 100 years from now, what do you think it'll be?
Well, I think it'll be similar to Justice Warren's legacy. There were things done during the Warren court that were not within the scope of the Constitution. And I think that in Justice Roberts' case, they'll probably find the same thing. But I think both Warren and Roberts are faced with the same problem, which is, as a Chief Justice, you have to get the work done. And the work requires 5 votes, and you got to make compromises. So if you were, Justice Thomas, he doesn't need to make any compromises. Justice Ketanji or Justice Sotomayor does not need to make compromises, and therefore they can stick to whatever line they want. But when you're Chief Justice, you've been put in charge of this collegial body, and you have a job to do. And that's what I think that Robert's legacy is going to be, that he did the job of being Chief Justice at a time when there was a divided court.
He's walking a high wire act.
Well, he's there for life, you know. He'll be dead when the histories are written, so I'm not sure how much he should care. But as long as the country remains at peace and the business of the country gets done, I guess he'd like to have everybody pat him on the back and say, oh, God, you were the greatest Chief Justice. I just love Justice Roberts. But, if you're expecting a friend, get a dog, but don't become Chief Justice of the United States.
I think he just wants people to know that he's doing his job.
I think he did his job. I think he's doing his job under tough circumstances.
On that note, appreciate you watching Politics and Power. Rod Sullivan, always a pleasure.
I enjoyed it.
Thank you.
See why every day more people are choosing News4JAX, Northeast Florida and South Georgia's #1 source for local news.